Thanks, Lisa. I had the great pleasure of serving with Lisa in the Office of Legal Counsel back in the good old days. I'm going to give a little bit of a background on the issues, and there are at least three very important issues, and we'll probably focus on two of them today that are present and central to the various pieces of legislation. Can everyone hear me? The pieces of legislation that are, speak up, that are now floating around on the Hill, both the administration's bill and the Graham-Warner-McCain bill. And there's a National Institute of Military Justice bill that's also out there. Everything derives from the June 29th decision of the Supreme Court in Hamdan versus Rumsfeld. And so I want to start with describing a little bit about why that case has precipitated this legislative debate and what the case was about, because I think there's a lot of misconceptions about it. Almost everyone expected, and every press treatment dealt with Hamdan as though the questions the court was being asked and that the questions the court would answer were two momentous questions. One, does the President of the United States have the inherent constitutional authority to convene military commissions to try detained enemies for violations of the laws of war? And if not, had Congress authorized the President to establish such military commissions? And the court, and that is still the way I think most people think of the case as having been decided, that the court held that the President did not have the authority to establish military commissions. And this common understanding is wrong. The court did not reach the question of whether the President had inherent constitutional authority to establish military commissions. It assumed for purposes of argument that he did, but more importantly, it assumed that even if he didn't, Congress had in 1950, if not earlier, authorized the establishment of military commissions to try enemies for violations of the laws of war. The court didn't quite hold that that was so, but it acknowledged that in previous cases the court had said that that was so. And so if the court did not reach the question of whether Congress had authorized or the President had inherent power to convene commissions, what did the court do? What the court did was to say that the President's commissions violated statutory restrictions in two respects. That is to say, they held that Congress had enacted laws in 1950 and earlier that imposed certain limits on those commissions, and that the President's commissions violated them. The first is they construed one provision of the law, of the Uniform Code of Military Justice, to require as a presumption that such military commissions have to be governed in accord with the rules for courts martial unless there's good reason, unless that's impracticable to do so and the executive comes forward with an explanation of how. So deviations from the courts martial system have to be justified in a particular respect. The second and related reason, but the one that has taken on, that is much more momentous, is that the court construed 10 U.S.C. 821 to require that military commissions comply with the laws of war, which makes sense. I mean, there's some debate about whether the court's reasoning on this, in this respect, was correct or not. There's disagreement on this panel about that. But to me, this makes perfect sense. We are, after all, trying people for violating the laws of war. And it seems to me inconceivable that any legislature, let alone the 1950 Congress, would have intended to provide the executive branch with the authority to violate the laws of war while we are trying people for having violated the laws of war. It makes sense that we would want the commissions themselves to comply with the laws of war. So that leads to the next step. What are the laws of war? And very significantly, the most significant part of the court's decision was the holding that what all of you have now heard of as know as Common Article 3 of the Geneva Conventions is a part of the laws of war that applies to our conflict with al-Qaeda. All right, this holding was very important. The President had determined in February of 2002 that Common Article 3 did not apply to the conflict with al-Qaeda. The court reversed that judgment and held that as a matter of treaty interpretation, the conflict with al-Qaeda is governed by Common Article 3 of Geneva. Common because it's in all four of the Geneva Conventions. Now, this has some implications for military commissions, and Gene and David will probably talk a little bit about that, what Common Article 3 requires with respect to military commissions. But this had much greater ramifications for another important component of the President's strategy against al-Qaeda, namely the techniques that the Central Intelligence Agency has been using since 2002 in interrogating detainees, especially high-level detainees who are al-Qaeda operatives, like Khalid Sheikh Mohammed and the like. And in particular, Common Article 3, it prohibits offenses against dignity and humiliating and degrading treatment, and those phrases have gotten a lot of play in the press. But much more importantly, Section 1A of Common Article 3 categorically prohibits all violence against detainees, including cruel treatment and torture. And the CIA has been engaged in what the President euphemistically referred to last week as alternative interrogation techniques to elicit information and intelligence from these high-level detainees at these secret black sites that by all press accounts have included the following. And I want to be careful here because we don't know for sure what the CIA has been doing because the administration hasn't confirmed this, but they have not foreclosed the possibility that these techniques have been used and could in the future be used. They have not taken any of these off the table, at least publicly. One is something called cold cell or hypothermia, described as where prisoners left to stand naked in a cell kept at 50 degrees for a number of days, during which he is doused with cold water. Another is long time standing. It sounds not so bad, and Secretary Rumsfeld sort of made light of it since he stands for 8 hours a day at his desk. But this is in which a prisoner is forced to stand handcuffed with his feet shackled to an eye bolt in the floor for more than 40 hours. It's a form of both a stress position and sleep deprivation, and there are reports of other forms of stress positions and sleep deprivation. And finally, threats of violence and death to the detainee and his family, something that was reportedly used for Khalid Sheikh Mohammed and perhaps others. Now, there's another technique that you've all heard a lot about, namely waterboarding, which is a couple different methods in which people are led to think that they are drowning, and apparently this has an extraordinarily powerful effect on the body and the human psyche and gets people to talk either truthfully or not very quickly. I have heard from several sources that the enactment of the McCain Amendment in December 2005 stopped waterboarding, that even the DOJ lawyers in the current OLC were not creative enough to think that waterboarding could comply with the McCain Amendment. I don't know that that's true, but my sense is that waterboarding probably came to a halt at the end of 2005, but that some or all of these other enhanced or alternative interrogation techniques continued until June 29th. And on June 29th, the court held that Common Article 3 applied, and I think the better reading of Common Article 3, the most reasonable reading of it, is that it prohibits these techniques. And so it probably stopped the CIA program in its tracks. And the President has now gone on record as saying, and Attorney General Gonzalez has told the Wall Street Journal, that without their bill, the CIA's enhanced techniques can no longer continue. In addition, now you've all heard a lot about the War Crimes Act. I'm sorry if I'm going too fast here, but I want to get our panelists in and have a lot of time for questions. Part of the problem is that the War Crimes Act, as amended in 1997, also makes it a crime, a felony, to violate Common Article 3. And so it is not only illegal in a way that OLC can't write around, but there's the threat of some attorney general down the line one day prosecuting someone for engaging in cold cell after the court had held in Hamdan that cruel treatment under Geneva is categorically prohibited. Okay, so we have the President, so to set up the discussion, and then I'll start asking some questions of our esteemed panelists, and I'll introduce them as I ask the first questions. The President's bill would, and I won't go into all the lawyers' details, we can in the Q&A to the extent folks are interested, or maybe Deborah would go more into it. The President's bill would, through several different machinations, would authorize the CIA to continue engaging in these, at least some of these techniques, on the theory that the McCain Amendment does not prohibit them, and would cut off judicial review of any questions about the interpretation of the Geneva Conventions altogether, thereby making OLC's word effectively the final word as to what does and does not violate Common Article 3 and or the McCain Amendment. Moreover, it would amend the War Crimes Act so to specify many different categories of conduct that would violate the War Crimes Act, but notably perhaps by coincidence, none of these enhanced CIA techniques are described among the crimes that would be made felonies under the new War Crimes Act. So the McCain-Warner-Graham alternative does some of these things, and in particular, it cuts off a lot of judicial review under habeas and other forms of appeal from questions of detention and the like. But it does not go so far as to say that the McCain Amendment completely covers what Common Article 3 prohibits. It does not go as far as the administration bill does in amending the War Crimes Act, although it does amend it to make it narrower. And it allows for some, although it's uncertain how much, judicial review of questions of the meaning of the Geneva Conventions. And before turning to questions, I just wanted to add a third. In addition to commissions and interrogation, there's a third big issue, which has been lurking, which is implicated by the two bills. And that is, who may be detained? What is the category of persons that may be detained by, pursuant to the authorization to use military force against al-Qaeda and the Taliban? Who can be detained? The administration bill has a definition of unlawful enemy combatant that is exceedingly broad, covers anyone affiliated with al-Qaeda, the Taliban, or affiliated with associated groups to the al-Qaeda or the Taliban, apparently without regard to what you might have done in connection with al-Qaeda or terrorist activities. The McCain-Graham-Warner bill, by contrast, says that an unlawful enemy combatant, and presumably that would be someone who could be detained, is someone who is engaged in an alien who is not a lawful combatant, who's engaged in hostilities against the United States. It's a somewhat vague and uncertain term, but it's certainly narrower than the administration bill with respect to who may be detained. All right, so I'm going to start with commissions. And questions about commissions. It could be that everyone in the room is only interested in the commissions part of it, not the interrogation and detention parts, but we'll get to everything, I hope, and then have time for Q's and A's. And I'm going to start by teeing up questions to David Rifkin and Gene Fidel on this. David is a partner at Baker and Hostetler and has served in many different capacities within the executive branch, and has dealt with many constitutional issues, including many related to national security and executive power and separation of powers. He served in Vice President George Bush's office as legal advisor to the counsel to the president, and as deputy director of the Office of Policy Development at the U.S. Department of Justice, which from time to time is called the Office of Legal Policy. What is it now? I don't know whether it's OLP or OPD now, but it's one of those. The acronyms change.
I think it's OLP.
OLP now, okay. He also served as Associate General Counsel to the Department of Energy to President George H.W. Bush, Bush 41, Special Assistant for Domestic Policy to Vice President Quayle. And prior to returning to private practice, he was Associate Executive Director and Counsel of the President's Council on Competitiveness at the White House. His resume is much longer than that, but many of you have probably heard David speak before, and you know that he's an expert on many of these issues. And I'll start by asking David then what he thinks are the most controversial of the provisions with respect to the procedures that would be established for military commissions, and in particular, in what principal ways would they diverge from the procedures for courts-martial, and are those diversions justified? How are they justified, and ought they be enacted, under the administration bill in particular?
Thank you, Marty. I'll be very brief to allow for as much debate and questions as possible. First point, the military commissions, as envisioned by this bill, courts-martial, are very, very, very similar and provide an enormous degree of procedural due process. There are a couple of deviations, but before I discuss the real question is why. The answer why, I think, is not just, to me, justifiable in instrumental sense, whatever needs of a prosecution. It's justifiable and necessary in a symbolic sense. To me, the notion that there should be some differences still have to be justified from a standpoint of fairness and due process. There should be some differences between the way you try lawful combatants who've committed crimes on an individual basis and became war criminals, and unlawful combatants who are always wrong, who are always, sorry to use the word evil, who are a danger to humanity, who can do nothing right. is fundamental, important, not invented in this war, not invented in this administration, has gone for centuries and centuries and centuries. And if you treat them exactly the same, what you're basically doing is not one of those instances, gee, why can't we be more generous and give folks a little bit more due process, a little bit more honor to which they're always entitled. What you've done is you eviscerated this distinction. You're legitimating implicitly their ways of waging war, which forget about American servicemen, which are fundamentally antithetical to all humanitarian values, because those people hide among civilians, attack civilians, and on both ends of a spectrum cause unimaginable problems. So they have to be different. Now, doesn't mean that they can be different in all respects. What are the two biggest differences? The so-called hearsay evidence and the possibility of excluding the defendant from portion of the proceedings. They're both fairly controversial. It's fair to say that, to me, the first one is easier to swallow. Why do I say that? Well, to the extent we care about international law, and by the way, international law has been hailed as the major imperative implicated here. How can we allow this deviation from international legal standards and the hearsay stuff? Ladies and gentlemen, that's not a serious argument, because first of all, what is the embodiment of international law dealing with evidentiary issues in the context of criminal trials? It's very new, shall we say. It really does not go back to even the Nuremberg Tribunal. I can explain why if you want to, but it really began with the Yugoslav Tribunal. If you look at the procedures for Yugoslav Tribunal, they allow, with some restrictions, broad admissibility of hearsay evidence. Again, we're going to have debates as to what hearsay evidence can go to under Rule 92 bis and all this other stuff. But let's just broadly say the notion that you can balance the due process rights of defendant with other policy imperatives is alive and well at the Yugoslav and Rwanda Tribunal. Ditto for Permanent International Criminal Court. It's good for the goose. It's good for the gander. And incidentally, these tribunals try both civilians and combatants. And certainly if we take our own constitutional law under the teaching of ex parte Milligan, a tribunal that tries civilians should render an even higher degree of due process. So to me, a mixed tribunal that sits in judgment on civilians and military, to the extent it allows hearsay, that's okay. Now, I suspect that most folks are more critical of a second provision, which is excluding the defendant. Look, it's a tough provision. It goes without saying that the right of confrontation is very, very important. And it goes without saying, and by the way, to be clear, it's only defendant who's going to be excluded. The lawyers would be there, and lawyers would be able to, properly cleared lawyers, and there certainly would be such members of a team, certainly military lawyers and civilian lawyers wants to go through a clearance process, which is not unusual, can cross-examine and interrogate the defendant and challenge everything. But I would submit to you, I agree, there's a smidgen, an important smidgen sometime, of information that only defendant would know. To use a silly hypothetical, that the defendant and the witness hate each other's guts from high school, and the defense counsel would not know about it. So it is a difficult and tough proposition. But first of all, there are several important caveats. It is an exceptional situation. We do have extensive opportunity for appeal, including to civilian justice system. And the only time you can exclude that if you're going to find that that does not deprive defendant of a fair trial. So not only the prosecution would have to convince the tribunal of that, but if you over-egg the pudding, if you will, you're on the risk that the justice system in the appellate review context, and that would be a very important issue to look at, would throw out the whole verdict. So I really think this would be used in exceptionally rare circumstances. What is the international practice in this area? I would argue that, again, if you look at the practice of the Yugoslav Tribunal, it's not exactly the same. There's no exact procedure for excluding defendants, but there are instances where you have witness testimony that is being introduced in one trial where if you can make an argument that there was adequate cross-examination by lawyers for defendant A, that evidence can be introduced in another case involving defendant B. And I would submit to you, ladies and gentlemen, how is that for the right to confrontation? What if a first set of lawyers in the context of trial involving defendant A were not particularly, shall we say, not particularly good? Even if it were very good, how does that fulfill an opportunity for the defendant B's lawyers and himself to be involved in it? And witnesses involved, by the way, can be anonymous. So not exactly the same animal, but the bottom line is, in this area as well, there's a balancing between the due process right of the defendants and the policy imperatives involving protection of witnesses and other factors. And this is being done by the cutting-edge international criminal tribunals that typically are extolled as to be progressive examples. I think this is a very reasonable balance. I think it's not going to be abused. I think in some degree this is a debate more about symbolism than reality.
Okay, I'm going to pick up on those comments with Eugene Fidel. Gene is a partner at Feldesman Tucker, Leifer and Fidel, and to most of us, we better know him as the president of the National Institute of Military Justice. And Gene is probably the preeminent expert on military commissions and courts martial. I believe he's written extensively on both, and has written many articles, edited and written books and articles on these issues, and is one of the most valuable, esteemed folks on these matters in D.C. and indeed anywhere in the country. I'll pose three quick questions, Gene, but you can ignore them, and if I've missed the most interesting parts of it. The first question is, why do both bills not simply start from the court-martial model, as your bill would have, and just deviate in those respects, such as on hearsay and access to classified information, where there's a perceived or articulated need to deviate? Why is it that they start from scratch and they both build an entire edifice of new system? Now, David suggests something very interesting that is not in the bills themselves and hasn't been articulated by the administration, which is this is meant to be, I don't know if David would call it punitive, but we ought to be treating unlawful combatants categorically differently, perhaps to deter such unlawful combatancy, right? So you should know that the trial you'll get will not be as protective as that lawful combatants would get, and that there's good reason for nations to do this, both symbolically and as a deterrent. I've also heard, and you can confirm or deny, that part of the reason is to try to get rid of all of the judicial precedents regarding courts martial as being a basis for interpreting this statute. And the second question would be, I guess, on the...
That was the first question?
That's the first question. And the second is more specific, which is the question of excluding the defendant from access to classified information. If the reason for this is, as many have suspected, that much of this information has come from dubious interrogation techniques that can't be revealed in court, what are we supposed to do in those cases if we can't have a trial where we reveal how we got the information from confederates of the defendant?
And I think you had a third.
I'll just stick with two.
All right, I'm just holding your feet to the fire here.
We have plenty of time.
Well, first of all, thanks to Marty and the sponsors of the program today for doing this. Let me make Marty blush. Marty has done an extraordinary job of not only keeping on track of unfolding developments, but also of probing them and probing people's take on those developments in ways that are really tremendously impressive and challenging. And many's the time I've read a post from Marty or an email and thought, oh, God, this is going to take hours to sort out. So thanks, sort of,
I think
Marty.
that's a compliment.
It's a compliment. It's intended as a compliment, yeah. I want to make a couple of preliminary observations, if I can, and then try to address some of Marty's questions. First of all, just to offer a brief biographical note, an autobiographical note, my government service was limited to 3 years, 7 months, and 8 days that I spent as a lawyer in the U.S. Coast Guard many years ago. I was once at a meeting on national security, and it was all people from the FBI and all the initial organizations. And the fellow across the table from me at breakfast said, were you ever, what did you do in the government? Or are you in the government? Or were you in the government? And without thinking about it, I said, no, I was in the Coast Guard. So I have a somewhat different take on some of these matters. Let me, just to finish the autobiographical point, for the last 35 years or so, I've been a student of the military justice system. And inevitably, I've taken positions that have been somewhat critical of the system. I think it's a system that we have much to be proud of but it's also a system that's not perfect. For example, it probably wouldn't pass muster under the European Convention on Human Rights. Nonetheless, and somewhat ironically, this is why I mention it, I find myself in a position of defending the system and speaking almost as a trustee in an odd way for it. That is a very odd evolution, but it's a responsibility that I and others in the National Institute of Military Justice feel very strongly about. David said, and here I'm going to disagree with Marty's characterization of David's introductory comment. Marty, I think, imputed to David a suggestion that deterrence was a factor, that we had to have a sort of tough system for enemy combatants as a means of deterring. I don't think that's what David said. He'll correct me if I'm misremembering this. What I thought David said was that the measure of due process that we afford enemy combatants is a function of their honor or lack of it. David certainly brought in the question of honor, and if I've mischaracterized again, please set me straight.
It's both.
It's both. My own feeling is that due process is a matter that we are committed to without respect to questions of honor. The only honor at stake when you're talking about what kind of process is due is our own honor as a nation. And so to the extent that David and I may differ on that, that's a sort of a philosophical matter, but I think it's important to point that out. For example, there are, and let me also hasten to say, nothing that I am going to say in these remarks about the military commissions and now presently about some pending courts-martial that we've all read about in the paper should be considered as convicting anyone. It's important that no one leap to conclusions by labeling people terrorists, for example, as unfortunately happened at the President's press conference. We're still, we have to indulge the assumption that no one has yet been convicted of a crime here. But we've all read about the pending courts-martial and preliminary investigations that have unfortunately emerged out of the war in Iraq. There are people who are suspected in those investigations of some terrible, terrible conduct. Does the fact that the conduct of which they're suspected deprive them of the right to due process? Does a person charged with a heinous murder lack that measure of honor so that we can throw the Constitution or simply our values out the window? That's a question that I think has to be confronted. To me, I think the highest priority has to be, now turning to Marty's questions, in designing this system, what is it that will respect our own, that will cause us to be faithful to ourselves? And also, what is it that will lead to or ensure public confidence in the administration of justice? We are talking about a system for administering justice. We're talking, and I believe public confidence is as central to the success of that undertaking as any other factors such as retribution, deterrence, and so forth. As we approach these issues, I think that we have a basic choice, and this, to some extent, Marty, will now invade the second part of your agenda. But I think as we approach these issues, we have a basic choice. We are either going to have, as somebody, the image somebody used, chalk on our spikes. In other words, we're going to be just pressing the limit, or we're going to build a fence around the law to make sure that we don't inadvertently transgress the limits. Now, that's my preliminary comment. Let me quickly turn to the questions that you posed. I understand why the administration bill, which has now been made progress on the Hill, on the House side, basically starts from scratch. It starts from the baseline set by the rules that had been prescribed by the President and the Secretary of Defense, rather than from the Uniform Code of Military Justice. And to a lesser extent, unfortunately, some of that is also true of the Senate bill, what I'll call the SASC bill. My own view was that it was wiser to respect the sort of internal logic of the Uniform Code of Military Justice, which currently affects military commissions as well as courts-martial. It currently is the statute on this subject. That it would be much better to work with the existing statute. I became very nervous when I saw that the House bill or the administration bill was 86 pages long and the SASC bill was 70-something pages long. My own view was that a bill of 5 or 6 pages would have been more than ample and would have, in fact, been faithful to the historic logic of our country's military justice legislation, which in fact has a tradition of delegating broad responsibility to the executive branch. No one seemed to like this suggestion, incidentally. Apparently people didn't trust the administration to do the right thing. My own view was that a broad delegation with some constraints was appropriate and desirable and would do less violence to the overall structure of the undertaking. I thought, for example, that a provision for judicial review, for, let's say, abuse of discretion, for those rules that depart from the general court-martial model would be sensible. A reporting requirement, things like that. Obviously, people on the Senate Armed Services Committee who have worked long and hard on the current measure, which is a very robust document, felt it was more desirable to have all of this enacted in positive law. Interestingly, what the SASC bill does is, in fact, a measure that's longer and, I believe, more detailed. I'd have to check a word count or something. But, I mean, you've got an entirely new statute for a handful of cases. It struck me as an odd and unfortunate policy choice that was made as SASC sort of developed its thinking on that. You asked, Marty, particularly about excluding the defendant from sessions that involve classified information. This has not been a problem under the UCMJ. There is a provision that permits classified information to be handled essentially as a carbon copy of the Classified Information Procedures Act. It's in the manual for courts-martial, so you never have the problem of an accused not being able to see evidence that is going in front of a trier of fact. It just never comes up. As for excluding the accused from the courtroom, it can be done under the UCMJ only if the accused is disruptive. So that particular aspect of the pending proposal is, I think, very unsound, and experience under the military justice system at least suggests that it's not necessary.
Before turning to interrogations and Deborah Pearlstein, Gene, David suggested that even the administration's bill was fully consistent with current international laws of war with respect to military commissions. The bill itself, both bills, purport to be consistent with the laws of war and suggest that they should be construed consistently with the laws of war. Is there any, very quickly, if you can, is there anything that you know of in the administration or the SASC bill that with respect to commissions that would be inconsistent with the laws of war as you know them?
Well, are you including the Common Article 3 in that definition?
Certainly, yeah.
Yeah, I mean, there's a problem, I think, in the effort to truncate or define in a truncating way what is coercive conduct.
On the commission side,
Yes.
though.
Yeah.
The exclusion of the...
Exclusion I don't recall, and I'll defer to others on that. What I can say is it's been suggested that hearsay evidence in general is readily admitted in international tribunals, and I know David is armed for bear on this, but my understanding of Article 92 bis of the Rwanda and Yugoslav tribunal rules is that hearsay can be admitted, but not on matters going to the conduct of the accused. So, you know, that is a major discrepancy between U.S. military law and the rules applied in those tribunals.
Let me just say one thing. Don't trust me. Trust former Judge Wald in the D.C. Circuit. If you look at the article she wrote a few years ago, she would tell you that the dividing line between evidence that goes to actus rea, well, forget the legalism, that goes to defendant's own conduct versus sort of scaffolding and supporting evidence is very, very difficult to draw, and let's just say that hearsay evidence permeates every single case in ICTY. But I'm not suggesting, and the rules on that have changed, I'm not suggesting we strike the same balance, but it is darn difficult for me to accept the proposition that an absolute bar against hearsay evidence is the rule of international law in this area, since the only rules of international law, I mean, the very fact that ICTY has repeatedly changed the rules in the last several years on this subject suggests to me that there is no rule of international law in this area, because, by the way, if you look at the original charge creating them, they're not supposed to be creating law. There is no law in this area. And let me just say one thing.
Let me finish my comment, if I can. I think, to some extent, it's there's an internal contradiction in the position that David, and I'm not imputing it simply to you, David, but you know, to that side of the debate, because there's an underlying hostility in the sponsorship of the administration's bill to reliance on foreign sources. I think it's very ironic. This country has not embraced the International Criminal Court. Even the SASC bill has a provision on page 82 that foreign sources of law cannot be considered in interpreting, you know, parts of the SASC bill. So, you know, I'm actually not particularly nourished by recourse to the rules, however fuzzy or not fuzzy they may be, under the Rwanda and Yugoslav tribunals. If you're going to have reference to international legal doctrine, then you can't, you know, what is it? I think it was Justice Scalia said that, you know, relying on precedent is like looking over a crowd and picking out your friends. You can't do that when you're talking about international law. Either you're going to treat it with respect and treat it as part of the discourse, or you're going to throw it out the window. And I think the basic stance of the administration has been not to rely on that.
That's actually a good transition to the question I wanted to ask Deborah about interrogations. The provision that Jean is referring to at the end of the SASC bill would prohibit the use of international sources to interpret Title 18, which is the U.S. Criminal Code, which is an odd provision, but it's new as of yesterday, I think. So Deborah, picking up on what Jean just said, online I have said that the administration bill would be authorization to the Central Intelligence Agency to engage in conduct that would put the United States in breach of Common Article 3. So this is momentous, not only because it's the question of should we be engaged in torture or quasi-torture or things close to torture, but also should we do so in a way that the entire world will reasonably and correctly perceive as placing us in breach of our Geneva Convention obligations. The bill itself and Condoleezza Rice yesterday, insists that that's not true. We're only construing Common Article 3 to be a sliding scale, sort of, that cruel treatment, whether treatment is cruel or not, depends on context, and that cold cell or waterboarding of one person might be cruel, but when it's really important, it might not be, and that therefore this is consistent with Geneva. Who's right, Condoleezza Rice or me? That's a loaded question.
You're right, Marty. Thanks for the question. I want to actually...
I didn't introduce Deborah because we want to take Q's and A's at 2. We were going to do it at 2 o'clock, but Deborah is director of the U.S. Law and Security Program at Human Rights First, a wonderful organization that's done amazing work online and off with respect to torture, interrogation, human rights more broadly. They do remarkable work. She's now also a visiting scholar at the Woodrow Wilson School at Princeton and is an expert in constitutional law, detention and interrogation affairs. I'm sorry, Deborah. So anyway.
Okay. So having said you're right, I mean, I think the administration's efforts, which I understand, to describe what the various pieces of legislation floating around now do as not somehow calling into question or undermining our Geneva Convention obligations, I think is more of a semantic and rhetorical exercise than a legal exercise. I think there's little question that the international community, and by international community I mean not only international legal scholars, but critically our close allies in the war on terror that's been described, will view this, and particularly the administration's proposal, as an assault on the fundamental meaning and idea and purpose of Common Article 3, which was to set a baseline minimum standard of humane treatment for anyone captured in the course of international or non-international armed conflict. And I say those terms as are terms of art that we can talk about it at length, what the difference is. But the point is that these are supposed to apply to anyone, anywhere, captured under any circumstances, no matter who they are and no matter who the capturing state is. What this bill, the administration's bill, in particular does is challenge that idea. So I want to, in response to that, be clear, and let me back up one step further, and since we are, I think questions are really kind of the most important thing, I just want to make a couple of broad remarks, but Marty's question sort of points to the first one, which is just to underscore. These bills are called the Military Commissions Act of 2006, but there is no sense in which these bills are primarily even about military commissions. These bills are by far the most sweeping piece of legislation to be considered post 9/11 that go to the core of the United States, and in particular the executive's power to capture, detain, interrogate, and try anyone in the world we believe is somehow involved in or associated with any act of terrorism. The potential of this bill, which we're considering at breakneck speed and hurrying to pass in the 2 weeks before midterm elections, has the potential to define what we're doing in the world and our view of the legality of it in a way that nothing that either the Congress has done or indeed any court has done since 2001. And by saying that, why do I underscore that? I think the key point is this. You know, we're taught in law school, or I was taught in law school, hard cases make bad law. What we're doing with this legislation is starting with a quintessential hard case. That is not terrorism is a major international threat. We're going to need to detain people. We're going to need to question them. We're going to need to try them. What's the best way as a matter of policy and the most legal way as a matter of law to do that? That's not the question or the set of questions we're asking. The set of questions that's being answered by this legislation is we have a mess at Guantanamo Bay. We have a mess in the secret detention sites that the President has now acknowledged worldwide. We didn't entirely think through in the days following 2001 what exactly we were doing with these people, what our plans for them were, or what we were going to do with the close to 15,000 people now currently still detained in the course of what the administration has called the War on Terror from Iraq to Afghanistan to Guantanamo and elsewhere. We didn't think it through. We've been doing things that the Supreme Court and other courts have now said either quite clearly or at least implied pretty clearly are unlawful, and now we have to fix that. Instead of narrowly fixing that, what this legislation is trying to do is answer every question going forward. So fix that problem, and in the course of fixing that problem, say everything we want to do in the war on terrorism. That's a mistaken way to make legislation, I would argue. So my vote would be, let's back way down and narrow this to the 5 or 6 page, here's what we're going to do with implementing military commissions. These are the small ways in which these trials should differ from the Uniform Code of Military Justice, and set the rest aside. Having said that, I want to address the Common Article 3 thing briefly, and then we can go to questions. And again, the Common Article 3 question here is only a piece of everything that this legislation does. The administration has said it wants to convey the message crystal clear that torture is bad, we don't torture, we don't tolerate torture, and in addition, there is something called cruel and human degrading treatment, which is a phrase that comes directly out of our Convention Against Torture, a different international treaty, obligations to which the United States is signatory and has ratified. It's also very closely tied to the language of Common Article 3 itself, to the Geneva Conventions. The administration says we want to make clear that these are bad and not tolerated. But what this bill does, in addition to defining that term, cruel and human degrading treatment, in a very narrow way that we can talk about, and more narrow than I think is accepted as the definition of Common Article 3, it says if you do these things, if you do a pretty wide range of these things, CIA in particular, because the Army has its own field manual that we'll talk about in a minute, if you do these things, the chances that you'll be criminally prosecuted, certainly criminally prosecuted under the War Crimes Act, are almost non-existent. If you've done these things since 2001, you will not be prosecuted in any way. Similarly, if you do these things, there is no way that any individual can take you into court civilly, either through habeas or any other civil statute like the Torture Victim Protection Act or any other mechanism. No way they can take you into court and make you stop, or at least exact some sort of punitive measure for your having done it. And furthermore, if you do these things, you may, depending on a discretionary provision, get the benefit of getting any information you've extracted, whether truthful or reliable or not. You may get the benefit of getting that information introduced into a proceeding later that enables us to detain indefinitely by trial, or indefinitely or by trial, whomever it was you were interrogating. So torture, cruel and human degrading treatment, bad, but if you do it, no problem. That's overstated, to be sure, and we should talk about the details, absolutely, and I want to be real clear. It doesn't do some things, it does do other things, but fundamentally, that's what the message that this bill sends. I want to just, last briefly on this point, respond to what I think is the primary argument that the administration and others have made in support of getting this bill and taking this legislation and describing what Common Article 3 actually means. And they say, quite rightly and laudably, this is a criminal, the War Crimes Act is a criminal statute. It needs to be clear. If we're going to prosecute anybody, U.S. soldier or anybody else, for violating it, we have to be crystal clear of about what conduct we think it would be a violation of Common Article 3, and I think that goal is absolutely right. It's required by the Constitution, among other things. But the idea that this bill somehow clarifies our obligations under Common Article 3, or indeed the meaning of the War Crimes Act in particular, I think is badly mistaken for a set of reasons. Number one, what every report out of the Department of Defense said in the wake of the Abu Ghraib torture and abuse scandal was there are too many standards here. you've got rapid tempo of operations, you've got Marines, you've got soldiers, you've got CIA, you've got special forces, you've got contractors. They're all operating in adjacent rooms, if not the same room. They all see what each other is doing, and they are all operating under a different standard of treatment. If you want to ensure that Abu Ghraib never happens again, make one standard of treatment, make it applicable across U.S. agencies, across U.S. forces, and make it clear. What this does, or would do, essentially, is codify the idea that the military's got one standard and the intelligence community has another standard. I think that's a recipe for the exact kind of confusion that we saw prevailing understandably, among our soldiers, and our 19 and 20-year-old troops. Number two, the idea that this standard, the Common Article III standard about cruel treatment, is somehow more vague or confusing than any other standard in U.S. law, I think is wrong. We ask police officers every day to apply the standard probable cause before they conduct searches and seizures, every day on the streets of America. Now, if you asked somebody what does probable cause mean, everybody would give you a different definition, but the reality is we have a raft of case law, guidelines and so forth, the equivalent of field manuals that interpret it and give pretty clear guidance to the police officer on the street what exactly it means. Common Article III is no more or less clear or vague than that. Furthermore, the administration, and here I'm going to massively telescope, what the administration says Common Article III means massively more or less is that it has to, the cruel treatment part of it is that it has to shock the conscience. That comes out of a Supreme Court decision. The conduct has to be so bad as to shock the average reasonable person's conscience. There are a thimbleful of decided cases in U.S. law under the Constitution about what exactly it means, shock the conscience, shock the judicial conscience, and I expect one judge has a different conscience than another. In contrast, there is a pretty now robust set of case law and decisions and commentary and other sources that interpret what the Common Article III standard on the Geneva Convention actually means. So we're taking one set of rules that have been elaborated pretty well and we're substituting it for a set of rules that have been elaborated almost not at all. Finally, if we really wanted to clarify that part of it, we could do what the administration is really vigorously refusing to do, which is take the recently introduced Army Field Manual standards, which has a long list, including waterboarding, of treatment that is prohibited if you're in the Army, and write that into law, because that would certainly be more clear than crystal clear in many respects in ways this legislation is written isn't. So let me stop there.
Okay, I know I have about 27 more questions, but they're not as interesting as the 25 minutes. And David, I do want to ask you, I'll turn one of the questions at some point in the next 25 minutes to whether you think the CIA techniques can be consistent with Common Article III. I assume that's what you wanted to respond to, but or anything else. But let me at least check at the outset to see how many questions there are and whether they will fill 25 minutes. And state your name, and I'll try to repeat the question. The question is, the administration wants the McCain Amendment standard, which is any conduct that would violate the 5th, 8th, and 14th Amendments, to replace the Common Article III standard, which is all cruel treatment and torture. I'll just speak briefly to that, and then I'll turn it to David. My understanding is that, as Deborah just suggested, the McCain Amendment, the shocks the conscience standard, which is the 5th Amendment standard, which is the most relevant here, maybe not the only relevant, but the most relevant here, it's been suggested by the Supreme Court that this is a conditional or context-dependent standard, so that what shocks the conscience as to one detainee in one circumstance might not for another. You take into account the reasons why the government is engaged in the conduct. Cold cell as to one sort of detainee might shock the conscience, and as to another it might not. They want that flexibility. Geneva has been construed, by contrast, to categorically prohibit certain categories of conduct, and I think cold cell and long time standing and stress positions would certainly, on almost anyone's definition, be cruel treatment, if not torture, under Geneva. But I know that David might not agree with that.
Thank you. Actually, that's what I was going to talk about. Look, we have to back up a little bit and remember we had a big debate last year in this country, and the debate was about how to treat detained unlawful enemy combatants. And that debate was in the context of CAT, Convention Against Torture, which you ratified and implemented. It was in the context of McCain language. I don't necessarily disagree in purely technical sense with Marty that even though the language in the McCain Amendment refers to cruel, inhuman, and degrading treatment of punishment, it does translate those international law terms into the constitutional framework by references to the 5th, 8th, and 14th Amendment. I don't have a whole day, but let me just say at the outset, and I don't think even Deborah would disagree, that's actually what countries are supposed to do. You take capacious, broad, I mean, maybe some of my colleagues don't think that words like outrages against personal dignity are capacious, but I do. And you take those words and you translate into your own constitutional lexicon. That's called compliance. That's called being law-abiding. So we came up with this language, and I agree that the reference to 5th, 8th, and 14th Amendment to the Constitution is somewhat more confining. By the way, is anybody embarrassed by that? Is anybody embarrassed by translating vague international law terms to the most sacred provisions in the Bill of Rights as interpreted by not this administration but by the Supreme Court over several hundred years, and thinks that that's somehow a bad thing, that is to suggest that we somehow have a shortfall of compliance? I'm not. But let me also say a couple of other things. That's not the only thing that's in place today. The administration's bill on page 80 adds additional prohibitions, absolutely banning torture. And frankly, torture is a darn canard. Not that there hasn't been torture on an individual basis in violation of the standard, but this administration has always been against torture from the very beginning. Nobody ever advocated torture. There's an explicit language banning torture here. There's explicit language banning human and degrading treatment. And maybe let's have a debate. Yeah, and by the way, definitions refer to severe physical abuse, severe physical and mental pain. And for those of you who are aficionados of this subject, this is not severe as defined by OLC. This is severe as defined in the original War Crimes Act. Now, to me, if you look at Common Article 3, torture is off the table, cruel treatment is off the table, inhumane treatment is off the table, degrading treatment is off the table. There's only one thing left being lawyer-like about it: humiliating treatment. I would submit it, at least in my view, there's probably a category of treatment that is not torture, is not cruel, is not degrading, is not inhumane, however you want to slice it, may be humiliating. And you know what? Shoot me, ladies and gentlemen, I would tell you that what is humiliating is so much in the eyes of a beholder. I think any criminal interrogation in any police station in this country is probably humiliating. Mutt and Jeff stuff is humiliating. Again, Marty, being a good lawyer, talks about waterboarding. I'm uncomfortable with waterboarding. I happen to think waterboarding is off the table because it is probably torture and certainly cruel treatment. But as far as humiliating treatment is concerned, loud music, you know, whatever this group is called, Chili Peppers, keeping somebody awake for a few hours and interrogating, shouting at somebody, spittle flying. Are we really going to take a serious position that those techniques are off the table in this particular context? And I cannot disagree more than ever. Yes, it's true that tough cases do not make good law. This is an old expression. But are we as people unable to make distinctions between coming up with rules that ban so much and preserve a very small standard for coercive treatment, very small, and say, no, we shouldn't allow that because we're all so confused that we cannot allow that exception to exist because it would pollinate everything else. By that standard, ladies and gentlemen, we should not use live ammunition during training because people can get confused and you know, going to have friendly fire incidents even outside of combat. So, and incidentally, we all know that the military manual as released now allows zip, nada, doesn't allow Mutt and Jeff. The only thing that you can do to an unlawful combatant. No, read that. You can do good cop, bad cop, but you better be careful that you don't threaten anybody. By that standard, you cannot do the kind of stuff in Miami Vice. The only thing you can do on the DOD manual is separation, which is a fancy term for solitary confinement. And for that, you need a senior commando approval. By the way, in federal and state penitentiaries, you can put a prisoner in solitary confinement for a long time. I don't think you need to go to the head of a Bureau of Prisons to figure it out. So we have now an absolutely abolitionist standard for the military. Okay? We've taken everything off of a table, cruel, degrading, inhuman, and torture, and the critics still want more. They basically do not want anything that can be called humiliating. Okay, let's have this debate, but let's be honest about it. Let's not hide behind Common Article 3.
Okay, David, and Jean wants to say something about this too, but we might argue about whether bombarding someone with Red Hot Chili Peppers or Eminem or Britney Spears or some of the above is humiliating or cruel treatment.
It's probably humiliating.
And we apparently agree that waterboarding should be off the table, but I think the important question is, do we have any agreement on whether cold cell and long-time standing and threats to the detainee's family are cruel treatment under the Geneva Conventions? Because these are the techniques that apparently the administration wishes to preserve.
Marty, we don't know the details, but let me tell you, as lawyers, we use terms like per se unlawful and all facts and circumstances. With regard to cold cells and keeping somebody awake, it very much depends for how long. If you interrogate somebody for 6 or 8 or 10 hours and the same interrogator is actually awake all the time with you, no, I don't think it's cruel. If you keep somebody awake for 3 days, it is probably cruel. Now, on the other hand, if you pull somebody's fingernails out, it's always cruel and torturous. So it depends. But I mean, why can't we be honest? The language that people are seeking now would ban all coercion. Why don't we admit that? Deborah, is there any coercion you think that is legitimate? Is shouting at the detainee, you know, in your face, spittle flying, calling the person names, is that not humiliating in your opinion?
Well, it's hard to know where to start with what you've said in characterizing my position. So let me, I guess, just take that last question. There is a large body of U.S. constitutional law, of which I'm a tremendous fan and think is incredibly important and applicable in all of these circumstances, which the administration disagrees with. But there is a large body of U.S. constitutional law, unlike the shocks of conscience jurisprudence, that says if you do the following sets of things, and there's a long list which would include long time standing, it would include tying somebody to a post outside, it would include prolonged sleep deprivation and so forth, denial of food and water and the rest of it, and it goes back for many decades, that says if you do these things to people in U.S. custody, you have created circumstances that are such that anything they say in those conditions is inherently unreliable and is involuntarily said. And under the Fifth Amendment, anything that emerges in those circumstances would be inadmissible in any court in the United States in any criminal proceeding. I think that standard, for example, much different from the one that as I understand it, the administration contemplates, that standard would be a fine standard with which to a fine standard to apply to questioning and rules of questioning that govern our treatment of people in U.S. custody. Now, that jurisprudence, I should hasten to add, doesn't do everything I, in my wildest dreams, would wish it to do. It does allow certain forms of questioning that I would think are coercive, but it is so much more attuned to what I have always understood and what I grew up in constitutional law understanding was treatment that civilized nations did not engage in. And if we were to import that set of case law and those amendments into this bill and into that discussion, I think we would be in tremendous shape compared to where we are now.
I think that it's important that we draw back a little bit and talk about what is really going on here. And each of us could probably begin a paragraph with that remark. Here's mine. There's a kind of unreality to this part of the discussion. I don't mean the discussion right here, but you know, nationally, because ordinarily, if you have legislation, the legislation is with a view to future events. If you have regulations, it's with a view to future events. If you're prescribing standards for the conduct of interrogations, police techniques, it's with a view to future interrogations. What's going on here is the retrofitting of rules for defining crimes, prescribing procedures for the trial of crimes, and setting interrogation standards for offenses or alleged offenses, conduct that has already occurred, and interrogations that have already occurred. A serious question here, and I'll leave the politics to others, that's not my thing, but a serious question is whether the effect of these documents, as a practical matter, either one of them, the administration bill or the SASC bill or any variant, is to grant impunity with respect to improper interrogations that have already occurred. That's the first observation. The second is, with respect to the suggestion that there are parts of Common Article 3 that are so vague that they need fleshing out in an act of Congress. Again, let us consider what that means. That is another way of saying, as a practical matter, they were, prior to the enactment of corrective or curative or clarifying legislation, too vague to form a basis for criminal prosecution. The phrase that I'm reading directly from Common Article 3, 1C, outrages upon personal dignity, in particular humiliating and degrading treatment. If you look at the Uniform Code of Military Justice, it has a number of what are called punitive articles. That's what prescribes crimes. Among them, and relevant to this discussion, is Article 93, which is 10 U.S.C. 893, which makes it a crime for persons subject to the code to treat persons subject to their control cruelly, to oppress them, to maltreat them. And I've only been doing this for about 35 years, but I've never yet heard of any suggestion that Article 93 is too vague to be a valid criminal statute. And if you look elsewhere in the UCMJ, you'll find comparable provisions. It is criminal in the military to be derelict in the performance of your duty. And on and on. The notion that Common Article 3, as adopted by the War Crimes Act, which is what happens, that's the way it fits into the U.S. Criminal Code, is too vague and needs clarifying, I think is untenable on its face. And I believe the effect of it, and I'll leave to others, sort of teasing out the intent, but the effect of it will be to confer a terrific argument for United States attorneys down the road to not pursue charges under the War Crimes Act, and for, in the event that people are charged, this, by the way, there's a number of cases that are backed up in the Eastern District of Virginia. Nobody seems to know what's happened to those cases. But if and when any of those cases or other cases, pre-existing cases, ever find their way into a federal district court, trust me, this legislation, if it or anything like it is enacted, will form the basis for a defense motion to dismiss, because the War Crimes Act was too vague.
I'm going to try to take a couple questions at a time because we only have about 8 to 10 more minutes. So the woman in red here and the gentleman standing in the back, and then I hope they'll somehow converge and we'll get a question. And the operative clause in 242 is what? What does the statute exactly say? Do you remember?
due process of law.
Let me get the question in the back, just because we have so many people who, yeah. So the question is, under the McCain Amendment, which would be the baseline standard under the administration's bill, are there things that are categorically prohibited, such as waterboarding, or does the McCain Amendment, like the administration suggests, does it establish this sort of sliding scale where some things that might shock the conscience in one case don't in another case?
My reading would be that, yes, the McCain Amendment prohibits waterboarding categorically, along with several other things categorically, but I betcha anything, that's a question that would be subject to a gigantic amount of litigation should it ever actually come up, and more importantly, unless this is made even clearer than it already is, I think the administration will interpret the McCain Amendment to continue to allow waterboarding. And I think the administration has actually been quite clear about that being their intention.
Although, Deborah, my understanding is that waterboarding is the one thing they have possibly thought does not survive the McCain Amendment.
Mark,
We've heard mixed things.
let me try to respond to this question a couple of things. I happen to think that waterboarding is off the table under the McCain Amendment. My view that waterboarding was off the table before the McCain Amendment, because I think waterboarding is not. Remember, the debate was not about torture. The debate was about cruel, inhumane, and degrading, and whether that had substantive meaning beyond, if you look at the original reservations, the CAT. And one thing we all should acknowledge is the body of U.S. law interpreting certain terms is not as extensive as some of my colleagues would like to suggest, primarily because in the U.S. domestic legal system, the cases arose in the context of abusing prisoners, not in the context of interrogation. But waterboarding is off the table. But on your key question, who is changing the law? Look, I hate to sound, well, no references to any person, but I hate to sound like I'm parsing words here. What is your what obligation are you talking about? Yes, the obligation exists since 1949 under Common Article 3, is humanely outrageous upon personal dignity, humiliating, all of that stuff. There's a question, then you translate this into the 96 War Crimes Act. With all due respect to my colleagues, there's enormous difference between parsing the language in the context of Civil Rights Act and words and expressions that have been parsed extensively by the Supreme Court prior to that statute being enacted. Apropos of a point made by Gene, a particular set of language in the UCMJ that is read in the context of the entire UCMJ, and numerous pre-existing precedents, because remember, UCMJ just recodification of articles of war, et cetera, going all the way back to Civil War. And having language like outrages against personal dignity, but to the best of my knowledge, have never been construed by any U.S. court. And to argue that in a penal statute you are going to give effect to that language suggests to me that you had some legal obligation, but for purposes of domestic law, probably you had no binding criminal law obligation. And talking about impunity, the 96 Act was never applied. It was not a, by the way, it's not a.
Can I ask you a question?
Yeah. Shoot.
The Geneva Convention has been the law of the United States since 1949. When did it become too vague?
Both of us know, Gene, that the law obligation means very different things in terms of a level of precision, ascertainability. If you're talking about an international law obligation, which in most respects to be vindicated, not for any binding adjudication of a tribunal, but to be vindicated for diplomatic discourse and the sort of normal hurly-burly of diplomacy, as distinct from an obligation in the United States that cannot be vindicated because there's no private right of action. And Geneva, by the way, it still is very much an open question after Hamdan, apropos point made by Marty, that except for the narrow aspect of Common Article 3, any of that is judicially enforceable.
It says here, this is paragraph 1 of Article 3. To this end, the following acts are and shall remain prohibited at any time and in any place whatsoever with respect to the above-mentioned persons. And then it's, among others, outrages upon personal dignity. So regardless of whether it was the War Crimes Act was in place, the United States government had an obligation starting from ratification of the Geneva Convention. So, you know, was it too vague for the United States to ratify this? We undertook this obligation.
But I mean, no, look, I don't want to sound very briefly. Yes, it's all true we had this obligation, but in most instances, the parameters of obligation are defined by sovereign states through practice, get defined, redefined, and evolved. There's no binding adjudication. There's no involvement by domestic courts. And the law means one thing at this level, Gene, you know it very well, we can accept vague and capacious terms, like there are many vague and capacious terms in Genocide Convention, because you're not going to have to argue it before an Article 3 judge. Doesn't mean it's in bad faith. It's just a different animal. What is happening?
I'm going to interrupt for a second, just because we're past 2:30. We're going to continue going because we got a little bit of a late start. No one, if you need to leave, that's great. If you want to stay, I think our panelists can stay for at least a few minutes more. And I know Deborah wants to speak to this question, but I want to get a good sense of also how many other questions are out there. I see 3 more hands. So we'll continue this discussion for a couple minutes, and then I'm going to take those 3 questions and leave it at that. I just want to suggest, I think that the administration's saying both things, both that their bill doesn't change the law, but at the same time they're claiming that if their bill isn't enacted, the CIA techniques will have to stop. And if the bill is enacted, they can continue. So there's some, at least some ambiguity there. But let me ask Deborah to interject into this tete-a-tete between David and Jean, and then...
Yeah, briefly, I think the Geneva Conventions, more so than probably any other international treaty obligation the United States has undertaken, has been interpreted, elaborated, and applied to U.S. citizens in tremendous detail for 50 years, and that is not only through the military justice system, but by the military. The military promulgated, and we've seen it recently revised, but they've been around forever, a set of directives, a set of guidelines, and a set of field manuals, a training curriculum, among other things, for the purpose of implementing the Geneva Convention obligations in U.S. military operations. Those guidelines are as clear, I think, as one might ever hope to find, no doubt more clear than one might ever get in a U.S. court about what exactly our obligations under the Geneva Conventions mean. And it is for that reason that you see the JAG lawyers, right, the military lawyers who grew up in this body of law, including its directives and guidelines and so forth, that everybody in the military has been trained in, particularly in the wake of Vietnam, but even before that. It's for that reason you see these lawyers who grew up with those lessons being among the most active and vocal defendants of the idea that this is crystal clear and we really don't need to start tinkering with it now.
Okay, there were 3 other hands. Where were they? Okay. Ed, then this gentleman, and the fellow in back.
What do you make of the fact
I actually think that, well, it's a civilian military divide, but it's also a military intelligence agency divide. And within the, I want to defend the administration here to a certain extent. There are many people within the administration who think not only that these techniques don't work, but that they're profoundly counterproductive in several respects. But there are those, and they're not crazy people, who think that these techniques lead to information, important information, that could not otherwise be obtained, and that the benefits of that information outweigh the costs. Those people are predominantly in the CIA, I think, and in the Vice President's office, not in the uniformed military. But I don't think it's the case that there's not a serious argument about costs and benefits that can be had.
Marty,
even if one thinks that as a moral matter, it's a cut and dried.
Can I just say hold on for a second. Let me just say this. To me, the debate is about moral issues, about humanity and honor. The argument that those techniques don't work is silly on its face, because humanity has been subjected, one set of people, another set of people, to coercive techniques for over 2,000 years. And they've been not doing it just for sadistic reasons. Let's stipulate, there are people with whom wonderful techniques of bonding and establishing rapport works. There are such people. They're not 100% of the population. They're certainly not the people who absolutely hate your guts and are prepared to die and kill you, number one. Number two, there are techniques of torture that work on a far wider spectrum than the techniques of bonding. And there are some probably in whom even torture does not work. And there are things in between, the coercive techniques that are not torture, not cruel, not inhumane. They work on a much wider body of people, not as many as torture, but to me, this is sort of an honest utilitarian argument. And you say, all right, let's strip away torture, inhumane and degrading, because no matter what their utilitarian benefits are, this is just not something we can do without losing our humanity. But let's not pretend that you're going to get everything out of Abu Zubaydah by trying to bond with him. That's silly. That's absolutely silly. And the point about the JAGs, there's nothing mysterious about the JAGs.
Now, Ed, we know there's a really, really serious debate about the costs and... But I think it's an interesting question. Ed has asked whether the CIA actually wants to be in the position of being the jailers and the interrogators.
But that's not an interesting question. Most people don't want to do. I wouldn't want to.
Interest some of us.
It's not an interesting question from public policy perspective. I wouldn't want to do this stuff either.
Let me interject a word.
Okay, Gene's going to interject a word, and then I'm going to take the last two questions.
Just very briefly, on Ed's question about the Judge Advocates General, I hope that there is some person with literary skills observing this whole episode that we're dealing with, and there is certainly a play, maybe a modernization of Billy Budd to be written in which the protagonist is not a sailor, in the forecastle, but an admiral dealing with, or a general dealing with the kind of ethical and professional issues that have dropped in the laps of the Judge Advocates General. I feel for them. I think it's a fascinating exercise. Someday, maybe sooner, maybe later, we'll get the inside story on it, but I'll be anxious to know what was the backstory on that letter.
Okay. I'm going to ask for both of the questions and then see if I can tee them up together. So. And the last question, I'll try to go. All right, let me do this one quickly then. The question is whether Common Article 3 standards, and here I want to diverge a little bit from both David and Gene. I think that the focus in the press on Section 1C and outrages on personal dignity and humiliating and degrading treatment is something of a red herring. I think the real question is what the phrases cruel treatment and torture mean in Section 1A. And the question is, to what extent is there a body of law or practice among international sources in armed conflicts of applying these terms to particular sorts of interrogation techniques?
I would say two things quickly. One, on the U.S. side is what I mentioned. The Army, the U.S. Army and the Armed Forces have a very clear understanding. I don't want to speak for the entire human rights community, but speaking for human rights first, we thought that the 92 field manual that's just been revised, but in many respects, although not all, in some good ways, but the 92 field manual complied effectively and in great detail with Common Article 3, and that generally speaking, that was the standard that the U.S. Armed Forces follow. So as a matter of practice, yes. As a matter of law and what is the rest of the international community doing, I think what matters most is, to the extent there's A, binding commentary on the Geneva Conventions, which there is, authoritative commentary, and B, authoritative interpretations by international courts of what those phrases mean. Those decisions are out there. I think we have here, and if not, happy to get you a little briefer on Common Article 3 that has in the footnotes some of the key decisions out of those international courts interpreting it. I think those are actually, you know, to a U.S. lawyer pretty clear about what they mean, and those are the binding court decisions that anybody in the U.S. would have to look to if you wanted to look at an international set of sources.
Can
I
I
agree with
just,
that, and I think it would be extremely ill-advised if we were to say that a person who had violated, you know, really the main understanding, let's say, of Common Article 3 could point to some decision or construction applied by, I'm not going to name a country, but, you know, pick a country. I don't want to insult anybody gratuitously. You know, where there was an aberrant view of what Common Article 3 forbade. I mean, certainly there are countries around the world that engage in, I'm told, behavior that we would find utterly unacceptable, and they may say, well, that's not, you know, that's not cruel. So in other words, I find that inquiry, I'm not faulting your question, but the direction of inquiry is one that I don't personally find particularly nourishing in terms of what ought to be done here, and whether this, whether the war crime statute's adoption and incorporation by reference of Common Article 3 left things too vague.
let me just say one thing about the U.S. practice, because what was said is technically true but very misleading. United States, since 1949, a variety of reasons, both Korean War, Vietnam War in particular, has chosen as a matter of policy discretion to adopt a higher standard, in my opinion, than that required by Article 3, a standard appropriate for POWs, which I haven't had a chance to mention to Gene. I mean, honor actually is a very important part of it. Our honor, the honor of the people we're dealing with, because remember, POWs cannot be subjected to any coercion whatsoever. You cannot even offer them oranges or pineapples in exchange for revealing anything, because they have a right, indeed an obligation, to protect their secrets. So what we have, a couple of generations of JAGs, honorable and well-meaning lawyers that they are, who have zero, nada practice of doing anything but POW-level protections, which exceeds the minimum standard of Common Article 3, and certainly is above that of dealing with unlawful enemy combatants. So it is enormously, and by the way, we chose to treat Viet Cong. They were in some ways better than Al-Qaeda, but certainly unlawful enemy combatants. We chose to treat them, and I've talked to people who were involved in that decision, in part because they threaten the lives of American POWs, in part for other reasons. So are we supposed to be locked in because of the over-compliance for 49 years that we chose to do? Okay, if that's what we want to do, it's a matter of policy, but let's not pretend that the 92 manual of prior U.S. practice is probative on the issue of what are the bare compliant contours of Common Article 3 is. And let me tell you, I don't want to name countries either, but the notion that it is not state practice, but it's writings of scholars at the University of Tübingen or some international bodies that define the meaning of a treaty is not something most international lawyers are going to agree with. State practice in this area has been quite appalling. Most people, signatories to Geneva Convention, have engaged in behavior vis-a-vis both lawful combatants whom they captured, unlawful combatants and civilians. That is nothing short of appalling. This is not to say that we should emulate them, but it certainly gravely weakens the proposition that there is this very high threshold out there that we're trenching upon.
Okay, David, this makes me very uncomfortable. This is the point that I was driving at before when I referred to building a fence around the law. I think that we cannot construe the Geneva Convention as if we were common law conveyancers, or reading a trust indenture. These are broad concepts of justice recognized around the world. I think we really have to err on the side of an expansive view rather than trying to find that limit that puts the chalk on our spikes.
Okay.
That is a basic question, and I think it's framed by your take on it.
We have one more question. We might have two. Thank you so much for all of your patience. You've all been very patient. I want to suggest that maybe everyone is right on this question. On questions of humiliating and degrading treatment and outrages, there might be a wide array of international ideas about whether yelling in someone's face or playing loud music violates Common Article 3.
It depends on the music, Mark.
It depends on the music. But what I want to suggest is that a good rule of thumb is that techniques that were often used in the torture chambers of Saddam Hussein and the Stalinist regime are presumptively prohibited by the cruel treatment prohibition in Common Article 3, and that's what cold cell and long time standing are.
If you actually want, catalog of international practices that was done for the purpose of discerning customary international law. The ICRC, the International Committee of the Red Cross, has just completed, I think last year, a comprehensive study on precisely this question, along with several others under customary international law. It's expensive, but the most and the only, as far as I know, authoritative volume that's done it.
Gentleman in the back, and then to the extent everyone has more patience, I have one more question over here. That's right. The question is, even in the Sask bill, the McCain bill, Senator Graham has insisted upon a provision that would effectively overrule the Rasool decision. And in Rasool, the court held that Congress had, by statute, provided aliens detained overseas, at least at Guantanamo, if not around the world, with the right to petition federal courts claiming that their detention violated the Constitution, statutes, or treaties of the United States. Senator Graham's provision would apparently cut off that right to statutory habeas, leaving open the question of whether that would be an unconstitutional suspension of a previously granted habeas right. And the question was to Deborah about what the implications of this might be.
Take 2 minutes, Deborah. You can.
And then to the train station. It's really hard to know actually how to go about answering that question. I think that provision of this of both versions that are out there, the McCain and the administration bill, is one of the primary reasons why I think, oh my God, back up, don't legislate everything at once before we go amending the habeas statute that was the subject of one of the most vigorous and heated oral arguments at the Supreme Court a few months ago I have ever heard about whether or not the last Graham-Levin amendment was affected a suspension of the writ. Neither version effectively answers that question, so we'll be right back in exactly the same litigating position, I think, that we've seen when the Hamdan decision was being argued before the Supreme Court a few months ago. In terms of its implications, I think they're potentially landmark and certainly unprecedented in that you would deny categorically to a massive class of people any access, any effective access to the U.S. courts. In effect, what it's saying is, in my view, although titularly the United States is a government of limited powers, anytime the United States government operates on individuals outside of the defined territory, the 50 states of the United States, there are no constitutional limits, much less treaty limits, on the government's actions. I think that implication flies in the face of the idea that we mean it when we say this is a government of limited powers. If you don't have a meaningful check by a different branch of the government, other than the executive, of what they're doing to people outside the United States, then I don't think you can effectively enforce that.
And what Deborah, to take Deborah's, or to add a footnote to Deborah's comment, what that does is open up an entire additional range of discussion about the nature of federal power, separate from this whole set of controversies. It is, what is the current meaning of the allocation of responsibility among the three branches of the government, which is like, if this isn't on a high enough level of abstraction, that takes it to a higher level, and the implications there. Marty, we need another panel.
We'll have another panel. Is this question
30 seconds. I'm confused. The court never reached constitutional issues, and with all due respect, Deborah, if there's a constitutional right to habeas for anybody anywhere in the world operated upon by the United States, then surely Congress cannot abolish it by statute. Congress in Rasul looked at the statutory habeas. There's extensive jurisprudence on when you can do something that changes the underlying statute without undoing a prior case. That's not infringed here. Congress in the Clean Air Act, Energy Policy Act, Natural Gas Act, all the time changes the statutory provisions that gave rise to long jurisprudence because they don't like results. And as far as Hamdan litigation is concerned, all they were talking about was retroactive application. And retroactive not because Congress cannot inherently retroactively apply something or jurisdiction stripped depending cases, because they weren't clear about it.
I'm not sure we disagree on this one. I think Deborah was just suggesting that it would tee up the constitutional question, not that it had been resolved in Rasul.
I would get teed up anyway.
And is it very quick? How?
That's great.
Great. I want to thank everyone for being extremely patient and our panelists for what has been a lively and I hope very informative discussion. To be continued.
As always, good to see you.